How did I treat you? I asked you a question about how you could have done that to me. Why that you didn't put my name on the house?
I explained this to you, so I told you I was going to put your name on the house. And I meant it. And I procrastinated, and I still owe you your name on the house.
On the record, John?
We are on the record in the matter case D22D. Please confirm your appearances.
Good morning, Your Honor. John Jones, bar number 6699, appearing on behalf of the plaintiff.
Good morning, Your Honor. John.
Who's present in my conference room.
Good morning.
Good morning, Your Honor. John Kelleher, bar number 6012, on behalf of Mr. Your Honor, who's also present here.
Good morning. All right, this is the time set for a hearing on plaintiff's motion to continue trial and extend discovery and related relief, and the opposition and counter motion, as well as a reply. Any stipulations to report on before we proceed?
No, Your Honor.
There was a stipulation that did come in just a short while ago that discussed, I believe, setting or related to discovery issues. So that being said, Mr. Jones, it's your motion. Is there anything you have to add beyond what's in the papers?
Yes, Your Honor. A couple of things discovery-wise that are new in terms of preparing for this hearing and preparing for defendant's deposition later today. It's learned that he has a new job with a company called MedCon that has never been disclosed before. He is business advisor and advisory board member. If you look at MedCon's website, he's the fourth one down in the executive team. That's something that's new. His most recent discovery responses state that he produced his 2022 tax return, but we don't have the 22 tax return in the production, because I went through it twice to make sure. And we also got a production of 400 documents yesterday, some of which are concerning because there's a couple of K-1s from limited partnerships, and it's kind of hard for me to show the court, because I didn't actually review the production that we got yesterday until this morning. But, you know, this is the document for a K-1. It's only like a screenshot of a quarter of the page. So I don't have any data regarding this K-1 for Enterprise Products Partners or the K-1 for MPLXLP. Now, I looked at the 2021 tax returns for these things to see if there was a reference to them in the 2021 return, and there was not. So there are some issues, and maybe I'll get some answers today at the deposition. But as far as the main issues, I think it was appropriate for defendant to ask the court to weigh in on, I guess, the interpretation of the prenup. To me, it seems pretty clear if there's not a specific waiver of any claim for the appreciation, and as you know, Judge, when you review prenups, the standard provision is my separate property is my separate property, increases in my separate property are my separate property, and even increases caused by my efforts during the marriage are my separate property. None of that is in this prenup. It says his separate property is his separate property, and he's entitled to the profits and distributions therefrom. It does not ever discuss the increase in value, which obviously, given the enforcement of the prenup, after a 14-year marriage, the court really has to construe these terms, A, not only against the drafter, but B, strictly construe them, and that if there's not an absolute waiver with specific language of a claim, that claim clearly survives under Nevada law. And the good news is it doesn't require a lot of effort for Jenny Allen to say, okay, this was the value on the date of marriage, the value that's set forth in the prenup, this is what he sold it for, here's what Pereira would show his separate property interest is, the rest is community property, and he owes her an equalization. By the same token, as you saw, the mortgage payment has been paid from the joint account throughout the marriage. So quitclaim deed or not quitclaim deed, which I think even the defendant would admit was because of my client's credit situation, you have a situation where significant community dollars have been paid, and we gave you an outline of all of the down payments made on the purchase of these homes coming from a joint account. So obviously there's Malmquist issues, or even if there was simply a reimbursement claim, it would be appropriate for Anthem to testify as to what that amount would be, rather than, I mean, the amount of time taken at trial for me to introduce every exhibit for every mortgage payment would be extremely long. So really, Judge, I'm not asking for a lot of time, because the report issues that I want to engage Anthem for are ones that are fairly simple to calculate, and I do believe that with this most recent production that we got yesterday, we now probably have all the information that Anthem would need. Obviously, the bigger issue is my client doesn't have the money to retain Anthem or to pay me to be able to get ready for this trial. As you know, when the prenup was upheld, that basically created an entirely new case for which I had a 90-day time frame. The final issue, Judge, is we still don't have a final custody order. We have a temporary, partial parenting plan. We said we agree on joint. I've told Mr. Kelleher, but we have to carve out special provisions for, because he hasn't been spending the same schedule with dad as the other children, and we still don't have a final agreement on custody. So there are multiple reasons to give the additional time. This is basically the only way mom can quantify her claims with the prenup being enforced is with this testimony.
So,
and the only way she can meet him on equal footing is with an award of fees.
well, you indicated that you don't believe you needed much additional time. How much are you asking for?
Well, enough time that I have the documents necessary that if I have the retainer for Anthem, which is $7,500, they could probably get me a report within 30 days, 45 days at the max. That would then give Mr. Kelleher his time to get a rebuttal expert. So it's really a matter of, if I get a report to Mr. Kelleher in 45 days, then we can set the timeline from there. And I know you have dates available because you run a pretty tight calendar that would allow us to, present the case pretty soon, within 60 to 90 days from the current trial date, yet still be able to get custody resolved beforehand. Because again, there's no final custody order, Judge, and be able to present this evidence.
All right, Mr. Kelleher.
Thank you, Your Honor. I appreciate the court's time, so I'm going to just take it one step at a time, if I may, Your Honor. There is zero good cause shown to continue this trial in any way. My client, Your Honor, as you pointed out to the court, is of advanced age, and we initially came into this court and asked the court a year ago, just about a year ago, they filed a complaint for divorce with the previous attorney in October of 2022. He's been out of his home for a period of nearly 12 months. The court granted the expedited date to have the prenup heard because very specifically, and I'd invite the court to look at it, Your Honor, we put this in our opposition, which was a brief opposition, that the representations were by opposing counsel that once you resolved the prenuptial agreement, the case was basically done. That there was no big issues to be raised in any way, shape, or form. In fact, not only did you confirm that at the very first date when you gave us the March date, but you also confirmed it again when we went to trial on the issue. You confirmed on the record, and it was confirmed by opposing counsel on the record that it would be joint physical, joint legal custody of the children. She testified in her deposition that it should be joint physical, joint legal with a split week, with a 2-2-5 schedule. So that's this being raised now today, Your Honor, for the first time is just nonsense.
Is that the schedule that's being followed?
Basically, yes. And we agree that they're oldest son, Your Honor, very respectfully, that their oldest son doesn't stay overnight at the home my client lives at, because as we pointed out to the court, all of his stuff, all the fancy equipment, everything is all at the marital residence. So as to he spends less time with dad overnights at his house than the other children do. But that's what they've been doing. And my client also has been in the marital residence, Your Honor, coming and going. Very respectful, if I can walk through some of the other issues, Your Honor. I don't know how much more clear this can be. We have a prenuptial agreement that was entered in the state of Pennsylvania. At the very first hearing, the court said that the Pennsylvania law would apply to all terms of the agreement. That's what was going to apply here. Why we're still now, 9 months later, almost a year later, still claiming that you're going to cite to Nevada law in some way to deal with the Pennsylvania prenup where they don't have community property. It is very clear within the confines of that document, Your Honor, that she waived both of them waived any rights to the separate property of the others. And on March, right, this is not some new issue. In March, I put in as our exhibit 1, date stamp 2007, there was a email that said what provision would preclude a Pereira claim, and we responded and gave them the provisions. That's dated March of 2022. So why are you waiting, right, after we've had a full hearing, right? We've taken depositions previously. 15,000 pages of documents have been produced in the discovery for a retired man. He's 100% retired. We did supply them. I have no idea why they continue to claim that we didn't supply the 22 tax return. If you look at our 8th supplemental production of documents, and they actually produced it to me. In their 9th production, the 2022 tax return is produced. He's retired. It's produced. Not only did we produce every tax return, Ron, going back to the date of the marriage, we also signed releases that were requested, and they made me get the releases. They wouldn't even bother providing me with the releases. They're like, you download them. We signed releases to go back to before the marriage and get his tax returns. They've had equal access to these tax returns, by the way. They're joint returns. They're joint tax returns each and every year. She's had them, she has equal access. In fact, and I want to be very clear about this, when he was ousted from his own home, he has an office and he has all kinds of paperwork in there. We asked through counsel to meet with her counsel and to get all the documentation together. They flatly refused to do that. In fact, what she did is she collected up all the documents in his office, gave them to her attorney produced them to me, right? So whatever documents they're claiming that would be from decades ago, whatever was there, she had full 100% sole control over those documents. And they're not even making that complaint. This other red herring that they're making today, Your Honor, I just want to address it right, head on. If you send me discovery, like just before the deadline is going to end, right, now on their 3rd set of requested production of documents, right, another 3rd set after he's already been deposed, after he's already answered 2 previous sets, and after he's been on the witness stand, now you ask for basically the same stuff. The stuff that we produced yesterday is they wanted every mortgage statement, right, from the current house going back. So we gave them everything that we had. It's completely irrelevant to what we're going to be doing in a week's time. Completely irrelevant. We don't deny, or whatever, that he makes the mortgage payments every month. Very respectfully, Your Honor, if I can just address these issues. First, there's no reason to continue this trial in any way, shape, or form. If they felt that they needed Pereira and Malmquist, they certainly told you that they needed it in March, right? They're telling me, and they put in their pretrial, right, to the court when we dealt with the prenup, in their own pretrial that said, well, if we lose that, then we may raise a Pereira claim, right? Pereira is not a Pennsylvania case, as the court knows. Van Camp is not a Pennsylvania term of art, so of course it doesn't appear those words in the document. It's very clear, extremely clear, that element 115 was listed as his separate property in multiple places, and multiple attorneys have looked at this, it shows over and over again that it would always remain his sole and separate property and she'd have no claim. And we've cited some of those paragraphs to him, to opposing counsel, paragraph 2A and 2B, and paragraph 1. So it's in there. It's in there, but of course it doesn't say Pereira Van Camp because that law isn't applicable in Pennsylvania. Number 2, Malmquist couldn't be any more clear on it. Malmquist deals with someone who owns a house prior to the marriage, right? And then after they get married, there's mortgage payments made and no other agreement is put in place. Here we started out with a prenuptial agreement. We had a series of homes. Her name doesn't appear on any of the mortgages or any of the titles of the other homes. She signed off on the home in Pennsylvania. She signed paperwork, I believe it was either a quick claim or grant bargain sale deed. And when this house was purchased in 2015, she signed a grant bargain and sale deed, which the court noted in its decision that you made on the prenup. So we have a prenup, we have a course of dealing, and we have a grant bargain and sale deed in 2015. Very respectfully, Your Honor, this has been and has never been anything other than an alimony case. That's it. We've said from the beginning, we understand there's going to be alimony here. The court, I don't want to say pleaded with her, but admonished her in a very nice way to go and get employment almost a year ago. And here we are, almost 12 months later, she's still not employed. And all of this motion is today, Your Honor. It's not good cause shown. There's no surprise. There's nothing that was dumped on them. They told you repeatedly that they weren't going to need much time, right, in any way, shape, or form. We responded to their discovery request that was sent at the last minute. He's going to be deposed today at 1 o'clock in the afternoon, so we're basically going to be leaving here and going and being deposed for a second time. Pereira and Van Camp don't apply. Malmquist doesn't apply. It's an alimony case, straight up, no questions about it.
Well, let me ask you in that regard, because and I've already made my findings regarding the prenuptial agreement.
Correct.
And certainly as it relates to the specific assets identified as part of that prenuptial agreement, and I attached the schedule that was part of that prenuptial agreement. And I'm not here to revisit that,
Right.
but certainly there are assets that have been discussed, and that's really the property, the real property, that were not specifically referenced in the prenuptial because they weren't owned at that point in time. The offer that's been made in the papers filed by the plaintiff suggests that over time there have been contributions that the plaintiff has made that have gone into these accounts that have then been used to pay these payments.
That's flat out false, Your Honor. She has not worked since they had, first of all, she has not worked since they had their first child. So she has not worked outside the home in any way, shape, or form since that period of time.
That's not.
Sorry. Oh, sorry. It's the third child. I apologize. Since the third child, Your Honor, she hasn't worked outside the home in any way, shape, or form. So no, she hasn't.
But up to that point in time, was she making contributions to accounts that were used to pay mortgage
No,
payments?
she was not.
Where did that money go?
She had her. My understanding is she had her own account, Your Honor. And I don't deny that my client had an account. You know what, Your Honor?
Yeah, don't interrupt. Please don't interrupt.
Yeah.
I'm not, Your Honor. I apologize, but I think
No,
he's
stop,
not telling the
stop.
truth.
Stop.
Right, into that 8-5.
Well, but my only point in all of this is there may be some factual issues as it relates to properties that were not specifically identified in the prenuptial. And so that becomes, that's why I'm not in a position to summarily dispose of these issues. I know that's one of the requests in the counter motion, because there may have been some contributions. I understand and listen, that was part of the discussion we've had at prior hearings, that once that prenuptial issue was resolved, we were, and that's one reason perhaps I looked at scheduling the evidentiary hearing. Basically, it was a 90 days from the date I issued my order, so it was not an extremely long period of time, and perhaps that was my perception, that you didn't need much time to get prepared, and I know that's part of the argument, but that's not to say that there may not be factual issues that I still need to to work through in determining whether or not there is any type of community property that falls outside the scope of the prenuptial agreement in assets that were not specifically identified. I want to be clear, my findings are what they are regarding the prenuptial. There's no redo in that regard, and to that extent, when assets were listed as part of the prenuptial, I am going to be looking at, because those assets were acquired essentially during the period of time that the parties resided in Pennsylvania. Maybe not always in Pennsylvania, but again, that's somewhat of a side issue. But I'm really more interested in knowing what factual issues that I may need to adjudicate when assets were acquired not in Pennsylvania, but were actually acquired here in Nevada.
Well, very respectful, and that's simple, because the only asset, literally the only asset that has any value, or any real value, would be the residence, right? It's one asset.
Right.
The other element, 115, I think you can, I mean, based on what you just told me, there's no reason that you can't rule on that today. How do you get a Pereira Van Camp if it's listed as, and with an ownership of 18% and a value placed on it, and it says that it's always going to be his separate, it's any accretions, any increases, all of that's in there.
It doesn't say that.
It's very, very clear, Your Honor, in that prenup, and I gave him the paragraphs. This is just, it's a ruse, Your Honor, to drag out and have him to continue to pay all of her costs and expenses and everything else. He even, right, in the vain hope of hoping that this thing would come to an end, he voluntarily gave her, he received opposing counsel, which they kind of gloss over, $20,000 more than what the court ordered in attorney's fees and costs.
When was the $20,000 paid? I know that was referenced in
It was
your opposition.
sometime between April and May. They're not denying it, that they received the money. So I'm just saying, beginning of April, Your Honor. We did provide a document on that in our exhibits. I can give you
Right,
that.
I know that was referenced.
So,
I just
you know,
I didn't
he's
recall the
received
date.
over $25,000, Your Honor, way more than what the court ordered he was to pay, done voluntarily. And now piling on to a guy at this point when he's living outside the home that the court's already found is his home, right, that he's been out of for what is almost 1 year, Your Honor. There's literally no reason to delay this case, none.
All right, Mr. Jones? Anything
Judge,
to add?
first of all, and my client did contribute to the joint account. There's no dispute that the down payment for the house that the parties are in came from the joint account. $106,000 of community dollars went for the purchase of the current home. And then every single mortgage payment from 2015 came from the joint account. So how he can say that doesn't create a community property claim, I'm sorry, that's a bad faith position. More importantly, Judge, the prenup's discussion of Pennsylvania law is about the interpretation of the prenup. Everyone in this room knows that regardless of whether the prenup is interpreted under Pennsylvania law, the law of the state in which the parties reside when the divorce action is filed is the law that controls the marital claims. I don't have the case citation here because I thought everybody knew that. But I can get you the case citation. So this idea, and again, the fact that it says this business, and just so you know, Judge, there is no reference to appreciation. Mr. Kelleher just told you that he cited to the paragraph of the prenup that talks about appreciation. It's nowhere in the document. It says that he has full control of his or her separate property, real, personal, and mixed, wherever the property is located. Each of the parties shall have and hereby is given the right to lease, sell, convey, mortgage, or otherwise dispose of their separate property and receive monies, rents, issues, income, and profits thereof without any restriction. Okay? So that is, this is my property and the profits of this property is my property. It doesn't say anything about an increase in the value of the property. There's nowhere in the premarital agreement that says the increase in premarital property remains premarital. So this idea that you would declare that Nevada law regarding the appreciation as a result of community efforts would not apply would, in my opinion, be legal error.
Your Honor, why don't you just read, if you look right at this paragraph that we put him at, which is paragraph 1 and then 2A and 2B, says, here's what it says. Says, except as otherwise expressly provided, this is on page 2 of the document, date stamp 64. Expressly provide each of the parties hereby waives, relinquishes, conveys, quick claims, bars, discharges, surrenders, and releases, and hereby agrees to waive, relinquish, convey, quick claim, bar, discharge, surrender, release to the other all the following. 3. Any and all of his or her right, title, and interest of every kind and description, which he or she may have acquired, enjoy, or be seized by reason of or after their marriage as the husband, wife, widow, or widower of the other party in the separate property of the other party, whether real, personal, and mixed, and wherever located, and then down again another paragraph, and any and all rights to any property of the other party titled in the other party's sole name, whether before or after marriage. So I don't know how much more clear it can be, and I completely disagree. If you look at as to this interpretation, Braddock, and this is something that you decided in the very first hearing. Braddock versus Braddock deals with this issue of properties located somewhere else and what law gets applied.
That's not this.
Right in the prenup, right, it says Pennsylvania law will apply. Community property in Nevada, and we gave you the definition of that, says things acquired after the marriage unless there's a written agreement otherwise. The prenup is the written agreement governed under Pennsylvania law and fully enforced after the court had a full evidentiary hearing, and there's a grant, bargain, and sale deed that she signed, right, at the time that he purchased the house in 2015. I don't know how much more clear it can be, but clearly, if the court, apparently the court wants to hear something on the house. As to the business, Your Honor, it is clearly not a Pereira case. It couldn't be any more obvious when you read this document that that's excluded.
Well, let me ask, Mr. Jones.
And Judge, again, the word appreciate.
Is Braddock still good law in terms of the court looking at the law of the state where the asset was acquired as governing the court's disposition? Because that's what Braddock provides. It specifically the nature of the rights of married persons in personal property acquired during the marriage is determined by the laws of that state, which is the matrimonial domicile of the parties at the time the property is acquired. Are you saying that's been reversed? Is that still good law in Nevada?
Well, Judge, I also am not, my recollection from when I practiced law in Pennsylvania is that there wouldn't, a marital claim could be against the appreciation in the business, the appreciation of separate property assets. Now, that may be something that needs to be briefed, but nothing in this agreement says she can't make a claim for the appreciation on this business, which resulted from his working in the business.
I don't respectfully. How can you even read that? Read it that way. It's date stamp 64. It's right there in plain, clear writing, in a paragraph 1 and paragraph 2, all the way down. But very respectfully, Your Honor, his answer to your question was no. Braddock is very good law. We brought that law to the court right in our answer to the complaint for divorce, and we filed a motion with the court at the outset, and the court heard from them what law was going to apply, and it was very plain, and everyone agreed at that time that it was going to be Pennsylvania law. Right?
No.
Listen, here's where I'm at, and this is what I'm trying to do. And I've had a chance to review the papers in preparation for today, and I note for the record that the original trial date, we had the evidentiary hearings as it related to the premarital agreement, and as part of the court's decision, findings, conclusions, and orders, I set the September trial date, which was about 90 days from the date that I issued that order. Certainly my hope was that with the resolution of that issue, things might even fall into place with a stipulated resolution, and this would be over and done with. I note this matter was initiated with the plaintiff's filing of the original complaint for divorce back in October 13th of 2022. So we're not yet at the year mark, and generally there's a desire to have these matters completed by that time. custody has been resolved based on stipulations that have been placed on the record previously, although it doesn't sound like everything's been reduced to writing at this point with respect to a final custody order. But I treat the parties' prior representations of the maintenance of a joint legal joint physical custody arrangement as a resolution with the final terms being worked out by counsel. And there are dueling issues that I'm looking at when I'm hearing factual disputes as it relates to assets that may have been acquired outside of the marital domicile in Pennsylvania, that assets that were acquired here in Nevada. So I'm not prepared to summarily dispose of any of the issues today. I intend to receive evidence. The trial date that was set in that original order, this is, as referenced in the motion, the first request to continue that trial. So I'm inclined to continue the trial. I'm not going to entertain any further financial relief, though, at this point. I'm going to set a new trial date, certainly to the extent that you believe that on either side, that there is some relief that you're going to obtain that is more favorable to your side regarding the division of assets and debts, then I expect you're going to make an offer to allow entry of decree, the offer of judgment provision under the statute. And you're going to make an offer that it is so significantly superior to what you believe the court's going to adjudicate at the time of trial that you'll be successful in having the court make an award of attorney's fees at that time. But I hear issues on plaintiff's side that she made contributions based on her employment, at least up until the third child was born, that there may have been some contributions. I don't know to what extent. To the extent the plaintiff was employed, that may assist the court in defining what the plaintiff is capable of earning. We get into the issue of work searches, and that was discussed in the papers. I'm not going to make any orders in that regard. But the income that was earned at that time, perhaps that helps the court in defining what the plaintiff's income is, because at the time of trial, as it relates to spousal support, I am going to be defining plaintiff's income, whether she's working or not. I need some historical information regarding what she's earned in the past to establish that amount. So that becomes valuable. I'm looking at continuing it for a full day. We have it set for a full day, and so I'm going to keep it at a full day evidentiary hearing to resolve the remaining financial issues. I'm looking at continuing trial to December 14th at 9 a.m.
Let me just take a quick look at my calendar, Your Honor. My phone was faster.
Your Honor, you're not inclined to, because we asked to at least flip-flop the home so my client could go back into the home, which is something that you had thought about before.
And I understand that. I'm just not inclined to entertain that. I'm going to continue the trial date. I'm not going to award any additional fees, and I'm going to give the new trial date, and that's effectively it.
December 14th is fine for me, Your Honor.
Any conflict with that, Mr. Kelleher?
Well, I had you know what, that's fine, I'll do the 14th, yeah.
I can look for an alternative date.
No, it's fine.
Okay. All right, so that's the new trial date. Do we need an order prepared, or the minutes sufficient?
Well, I don't know.
Your Honor, I just need to be clear. You're not ruling on the request for declaratory relief at this time.
I'm not summarily disposing of anything at this point.
Okay.
I've somewhat made my position clear, and I believe Braddock still does apply, and so that's what I'm going to be looking at. But
you agree, though, Judge, that
as it relates to the division of assets, which, as Mr. Kelleher indicated, I thought had been largely resolved with the adjudication of the prenuptial agreement, make your offer to allow entry of decree on both sides, and do it in a manner where you make an offer that you believe is significantly better than what the other party is going to get at the time of trial.
The problem with that, Your Honor, is that the main issue here is going to be alimony, which is not amenable to an offer.
You're right. And I get that.
It's
specifically precluded from
exactly,
that, and I get that.
So
Okay. Any orders?
I'm fine.
No, I think that's sufficient, Your Honor.
Okay.
Okay,
Thank you, Your Honor.
all right, thank you for your appearances.
I'm sorry, one last thing. So are we?
Discovery would be extended as well, so my client can sell a kidney to retain Anthem.
Well, very respectfully, our position would be.
Discovery will close on November 27th.
Okay, thank you very much, Your Honor.
All right, thank you for your appearances.
All right, so.
You know what would be the most joyous moment of my life?
Insult?
No, when I kick your ass out of here.